Well, good afternoon and welcome to today's webinar. I'm Beth Hawley with the Arizona Association of Realtors, and we're proud to bring you these complimentary webinars designed exclusively for Arizona Realtors. Today's webinar, excuse me for a moment. Today's webinar is Understanding the Eviction Process with Denise Holliday. Denise is an active attorney who has built a practice around landlord-tenant law. Today's presentation will be about 35 to 45 minutes. If you have any questions during the webinar, please write them in the question box and we will try to get to them at the conclusion of the webinar. If you'd like to change the size of the screen between the video and the PowerPoint, just click on the line separating the webcam and the PowerPoint presentation and drag. As always, today's webinar will be recorded and available next week on our website at aaronline.com. So welcome and let's get started. Hello, Denise.
Hi, everybody. It's so good to see you. I am excited to be bringing you this class. As most of you know, I am an eviction attorney and have been for over 20 years. This particular class is being offered about really understanding the entire eviction process. Where do we start? How do we go through it? What happens while we're in an eviction? And then really, what does it mean? So this is my firm. If you have any questions, feel free to send me an email afterwards. You can send it to Holiday with 2 L's at drvictor.com. So let's just jump in. I'd like to know, first of all, how many of you are property managers? So a quick online survey. You have an idea? So please answer the poll real quick. We're just looking to see, helps me understand how many of you have been through this process. So terrific. Anybody answering that yet? Okay, so this, I'm going to start just from the very beginning and let's talk about it. As you can see by this particular slide, everyone presumes landlords are evil and wicked and always want to throw out their tenants. Sadly, from my point of view, evictions are just a necessary evil. In order for us to have decent property prices and good rental rates, we have to have evictions because we have to get rid of someone who won't pay the rent, won't follow the rules. This is not our desire. All of us want to have tenants that stay there for 20 years, pay the rent every single day, and help us pay off the mortgage, right? So let's take a brief overview about what we're going to talk about today. We're going to start with, do you know the type of notices, what's out there? Then how do you choose that particular notice? How do you include the right language so when you get to court, you don't have the case accidentally thrown out by a judge? What are the correct steps leading up to the actual eviction? What happens in that eviction process? How can we accidentally have a minefield of issues? And then how do we get through those? How do we understand what happens actually in court? And then completing the last process of the lockout and dealing with the security deposit disposition. So the first thing is start with a really good lease. Hopefully all of you are using the AAR lease. If you are, you're on to a really good place. However, there's a couple of things I want you to think about adding. The most important one is a jury trial waiver. If we have to go to court, we sure want to keep those costs down. Would really like to just be able to go directly in front of a judge. You can do that quickly for just a few $100s versus if you have a jury trial that can take thousands and thousands of dollars in weeks. So we start out by all the different types of notices that you can serve. We're going to presume everybody here is going to be talking about an eviction that's a residential eviction. House, apartment, when you rent a bedroom out of your home. If you have a trailer but you own the trailer and it's sitting on your land, that would also be an eviction. The Arizona Residential Landlord-Tenant Act really governs what we need to know about notices and when we can give them and what the tenant's rights are. So the very beginning starting point is, do you know what type of notice is available and then what you need to say in that notice? So here are the various types of notices. There are other ones, but these are the basic ones. The 5-day non-pay. If you're in property management, you're very familiar with that. In fact, you're probably preparing those right now while you're in the process of watching this webinar. Those typically go out right after the first day of the month. Many of you have grace periods of 3 to 4 days, and so you're probably preparing your 5-day notices right now. A 10-day notice is a notice given for general breaches. Illegal parking, noise, dogs, kind of all the general stuff. really everything that there's not a specific time frame to cure or not cure. If the tenant doesn't fix that the second time, we give a second 10-day. Sometimes those 10-day or the regular breaches are pretty serious. And if they're pretty serious, we need them to rectify the issue faster. That's called a 5-day health and safety. Sometimes whatever that breach is so serious, we need to get them out right now. And the last one is, it's not that I don't really have a problem with you. You've been a great tenant. Just really want to raise the rates, want to sell the property, want to rehab it, or maybe you've not been a very good tenant. I just don't want to live with you anymore. And that's called a non-renewal. The tenant can give that notice or the landlord can give the notice. So let's take a real quick look at what type of notices we just walked through. This is the first one, most common. It's called the 5-day non-pay. What it has to say is, specifically, you owe me rent. And it also has to say, here's how I figured out how much you owe me. It's important that you have that verbiage very clearly so that a judge, when they're reading the notice, can figure it out. I think probably many of you know I am a pro tem judge and have been for about 15, maybe 16, 17 years. I find it frustrating when I'm reading a notice and a landlord's standing in front of me and I have no idea how much money I'm supposed to add to this judgment. And here's why that's frustrating. If I can't figure it out, a tenant can't figure it out. And if it's some kind of moving target, the judge is going to throw your case out because it's not clear enough for the tenant to know how to cure the breach. So be specific. How much is owed? And then how did you get that? Is it 1 month's rent? Is it September's rent with a balance left over from last month? You don't have to explain what the balance is from or what it was exactly, like late fees and a broken window or whatever. You just have to say a prior balance of. And then if you're going to say $365 in late fees, you need to explain to the tenant how you got that number and how is that number going to continue to increase. So if it's going to be $5 a day, is it $5 plus tax a day? So is it really $5.36? And then how much does that accrue? Is it every day? Is it a one-time amount? Is there some kind of cap? If you're using an AAR lease, go back and look at it and be careful. Many people, when they first fill it out and aren't familiar with that lease, where it says late fees, they put something down like $5. Well, that means $5 for the month. It needs that in the blank space. It has to have a dollar sign, $5 or $10 or whatever that amount is, and the slash sign or the word per day, because otherwise it's $5 for the whole entire month. So go back and look at your leases. So be specific. If you're going to charge something else in a 5-day, it has to be something you're allowed to get in a 5-day. And there aren't a lot of things you're allowed to get in a 5-day notice. If there are other monies that are owed, they're really in a 10-day notice. If the tenant didn't pay all of their deposit, if they had a broken window, if they had a fine from an HOA or a city, all the other money that's owed would be under a 10-day notice because it's not a monthly reoccurring charge. So if there's going to be fines and other types of things, put those on a 10-day non-compliance, not on a 5-day non-payment of rent notice. After you've issued that notice, be careful. You can accidentally waive some rights just because you weren't sure about what you were doing. You have the right to refuse the tenant's money before we get to the judgment, only if they're not paying you all of what is owed. So let me give you, for instance, it's now September 5th. Over the weekend, the tenant dropped in the drop box $752. But today is now September. If you take that rent money, which was last month's rent money, and you apply it, you have now waived your right to proceed with an eviction for this month, for September. So even if you issue a 5-day notice for September right now, you can't even file with the court until October. There's a special statute, for those of you taking notes, it's ARS 33-1371, and that's called the partial performance statute. If you allow a tenant to do something and without them requiring them to do everything, you lose some rights. So don't take a partial payment unless you have them sign a non-waiver. We call it a partial payment non-waiver. And there's lots of those. We have them free on our website. It's important that they sign it at the time you're taking the partial payment. If they won't sign that agreement or you don't want to accept a partial amount, you need to send it back. Many times by the time I get to court, the landlord says, I didn't accept the money. The tenant says, I never got it. And the question for the court is, where is it? If it's in your possession, including in your drawer or in your bank account or in your safe, you've accepted it, and now you're going to lose your eviction case. So treat that like a game of hot potato. Get it out of your office, send it to the tenant, send it certified mail. If it comes back to you before court, you can hold those monies in the sealed envelope, take them with you to court to show the judge you did not accept them, but you can't keep sending them back and forth because the tenant didn't pick them up. So remember, if the tenant's going to pay you everything that's owed, rent, late fees, court costs, attorney's fees, you must take it as long as it's every single penny up to the moment that you're taking it. Now, that's important, but after court, from the moment the judge signs it, you can say, thank you very much, you owe me the money, but I'm not going to let you stay. I may even accept the money, but I'm still not going to reinstate your lease. If you're going to do that, that's a different type of form. It says, I'm accepting your money after court, but I'm not reinstating the lease. You need to move out. Don't cash that money unless the tenant's very clear that you're not keeping those funds. The next most common type of notice is called the 10-day non-compliance notice. Those are very cute pigs, but they're unauthorized. So you give a 10-day notice for unauthorized animals. Of course, that's hopefully not parking here in Arizona. May have gotten there other ways, but unauthorized parking would be a general 10-day notice. A 10-day notice says, this is the problem and you have 10 days to fix it. If you don't fix it in 10 days, I'm going to file the eviction. So the question is, you have to know, did they fix it? If you're going to do an eviction for a 10-day breach, what evidence do you have that after the 10-day period they did not fix it? So maybe you should be issuing an access notice telling them I'm coming in on the 11th day. But either way, you need to find out, is that thing fixed or not? Sometimes it looks like it's fixed, but it's not. So what happens is that they say, oh, the dog is gone. It was just an accident. And the bowl's gone, and the water bowl, and the food bowl, and the leashes are all gone. And then 3 weeks from now, you hear a complaint from a neighbor, hey, the dog is back. When the person does the same type of issue again, so not just the first time, but the second time, and that could be really any time in the lease. So if they did it 6 months ago, they're doing it again, that's called a second 10-day notice. That one terminates the lease. It's not curable. It says, Mary, you're the tenant. On July 2017, I gave you a 10-day notice for illegal parking. It's just been reported that you're parking illegally again. You have 10 days to move. The second one is not curable. It says you must leave. If they don't leave within that 10 days, then you file the eviction action. So we were talking about, like, say, this particular picture. What if whatever that is more serious than just a regular 10-day notice? What if it looks like that? Okay? That's called a 5-day health and safety. It basically is a 10-day notice on steroids. Something that's bad, but is so bad we need to have you stop it faster. The home is really, really dirty. This home is more than that. If the whole house looks just like this, that's a health and safety hazard. It could cause a fire. We see that a lot with the hoarding situations. You have an unauthorized animal, but now this unauthorized dog is growling and trying to jump over the fence, and we're afraid it's going to eat the neighbors or the post office guy. So we need to give a faster notice saying get out sooner. If whatever the breach is dangerous, like a crime, shooting, stabbings, drugs, prostitution, gang activity, some kind of threat, that's an immediate. Okay? Always remember, an immediate is basically a crime or a threat of a crime or a situation that's so dangerous we have no choice but to take a step right now to make you leave. It is not curable. They have to move out immediately. And if they don't, we can file the eviction the same day. This is not used when you've told the tenant 5 or 6 times, don't do whatever. So they've had the unauthorized occupant, they've been parking illegally. The final time when you're finished and you just don't want to deal with it anymore, that is not an immediate. Always think about immediate as a crime. Shooting, stabbings, drugs, prostitution, gang activity, threats, something that's so dangerous we have to have them move right now. Now, sometimes there's really nothing wrong, or there's lots of little things that are wrong, but nothing really you can do an eviction on, or maybe you just don't want to own the property anymore. Many of you probably have owners right now that didn't really want to be a property man or a landlord back then, and just really the property was upside down and didn't have a choice. So now they really want to get rid of the home prices are good, and you just don't want to have this particular tenant there. You want to be able to open up the market to anybody who wants to buy it, not just an investor. That's considered a non-renewal notice. What it says is, it's not that there's anything wrong. I just don't want to have a contract with you anymore. And that's okay. Either party can give it. So the key to this particular notice is you have to give the notice 30 days before the last day of the month or the rental period that they're living there. So if you decided on September 1st, gosh, I just don't want to rent to this tenant anymore, the owner wants to sell, you're going to have a hard time giving a notice to the tenant on the 30th of September. They had to receive that notice the day before, not really on the 1st of the month, although some judges may allow that to still go through. Remember, if you didn't hand deliver that notice, if you mailed it, you're going to have a problem because they didn't receive the notice till after the first day of the month. So all breach notices can be given any time. Any non-renewal notice has to be at least 30 days before the last rental period and the last date of the rental period. Some people actually have 60-day notices written in your lease. That's actually okay. The statute's 33-1375, and what it says is at least 30 days notice. So what actually goes in the notice? The language itself needs to be specific. It needs to explain to the tenant what's wrong and why you're asking them to leave. Please be careful. You need to be specific. What happened? Did someone see it? What's your evidence? When did it happen? Was it the tenant? Was it their guest? What did they do or not do? If that breach notice is not clear, like for instance, let's say you say, disturbing the quiet enjoyment. Okay, how? When? Who did that? If you don't include that, the tenant may not have enough information to decide, how do I fix it? And if the tenant doesn't know what to do, then you're going to have your eviction dismissed. We have a new set of laws starting in 2009, so not so new anymore, called the Rules of Procedure for Eviction Actions. They specifically say if you can't tell the tenant very specifically in writing what they did wrong, then you don't have the right to maintain an eviction case. So what do you do after you issue the notice? Okay, first you have to decide when you're issuing the notice, is it a curable notice or a non-curable notice? Can you get rid of the dog? Can you stop making the noise? Can you pay what's owed? Or is it non-curable? Shooting, how do you unshoot somebody? How do you unstab somebody or unsell drugs? Those are things that are non-curable. A non-renewal is a non-curable breach. However, you would still take the last month's rent for January because they have until the end of the month to cure that issue. So the first one is wait the proper time. Is it 5 days, 10 days? Once that time frame has passed, do you have evidence that they're still in breach? The second thing is don't forget to wait the right amount of time to pass before you file the eviction action. The way it works is, let's say you're going to issue a 5-day non-pay. Today's the 5th. Are you going to hand deliver it to a tenant? If so, who did you hand it to? What were they wearing? Do they have to sign the notice? No, but you got to have proof you actually handed it to somebody. So we don't count the day that you actually give the notice. We start counting the day after that. Many of you have had me in a class before and you know I use my fingers. I think this is the easiest way for us to remember because most of us have 10 of these. So if you're giving a breach notice for non-payment of rent today, you don't count today. So don't put a finger up. So we start counting tomorrow. 6, 7, 8, 9, 10. When you run out of fingers, you can file it with a court. So on the 11th, you'd file it with a court. However, if in fact you give the notice, say on the 5th, so 6, 7, 8, 9, 10, but you have to mail it to somebody because you're not going to walk out to all those doors. You're just going to send it to them and mail it to them. You have to mail it certified or registered mail. That adds 5 days for mailing. So that becomes a 10-day notice. So if we send it on the 5th, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, when you run out of fingers, so on the 16th, then you could file the eviction. It's no more than 5 days for mailing. And then if they don't pick it up, which most tenants do not, we just pretend like they got it. It's called deemed received. If the tenant signs for it sooner, let's say when you send it on the 5th, they sign for it on the 7th. So you go 8, 9, 10, 11, 12. On the 13th, you would be able to file the eviction. Be really careful. The math part can get people in trouble. I always joke and say if you're not good at math, you probably don't want to be a property manager. We deal with a lot of math. But be careful. Don't send it to an eviction unless it's actually been ripe or completed. That time frame's expired. Also, beware of waiver issues. You can accidentally waive your right to go to court by mistakes. Here's how I typically see it. You take the money from the tenant on the 1st because they're paying for last month. Their rent's not late until the 3rd. So you accept the money, but you didn't get a promise to pay or partial payment non-waiver. Really, they're the same thing. If the tenant didn't sign it, you have to send the money back, or you can't do anything during the next month. The bigger problem that we see is when you give a different type of breach notice, like let's say a 10-day for noise. So they have a big party, you gave them a 10-day notice, you gave them the 10-day notice, say on the 25th. So 26, 27, 28, 29, 30, 1, 2, 3, 4, 5, you can go to court on the 6th. They come in and pay the rent on the 3rd. If you took the rent on the 3rd, you have lost your right to evict them on the 10-day notice. And now you have to wait until they do it again. You have waived your right to proceed on that notice anytime you take money, even if that money was for something different, or it's for rent that's due now and they still have 10 more days or 8 more days to fix the breach issue. So be careful about waiving your rights. That happens pretty frequently. So you've issued notices, you've waited an amount of time, the tenant didn't fix it. Now we're going to go to court. So we're going to file it with the court, and remember, the anatomy or the breakdown of what we do is very important so you understand and do it correctly. You're the first line of defense, you're the property manager, the owner's going to be having this conversation with you. Well, why are we evicting them? Well, isn't it better to let them stay and make a payment? How much will that cost me? All of those things, how much time will it take? You need to know those answers because the landlord's expecting you to know. So here's the first step. We issue what's called a summons and complaint. And in that summons and complaint, we have to tell the court what was wrong, why are we filing, who is filing, who's the correct parties, what's the actual name of the party that is the landlord. So that's mean the legal entity. It can be care of you, Mary, property manager, but it has to be brought in the name of the actual legal owner. So you need to have that information. We also have to serve them a copy of the summons and complaint. This service is different than the service of the notice. Service of a notice can be done by anyone. It can be done by you. It can be done by your family member. It can be done by the owner. It can be done by a neighbor. It just has to be done, and we have to have proof. Service of process is the paperwork, the legal documents from the court. That has to be done by a process server, and that has to be an Arizona process server. If you're in a small town, you may not have any process servers. So your constable or your sheriff, sometimes even your police department may actually serve those for you. So we have the summons. That's the document that's part of the Arizona Residential Landlord-Tenant Act that says the landlord is suing you and wants you to come to court. It also explains that if you don't come to court, you're going to potentially be evicted. That particular document also says if you're disabled or if you need some kind of special arrangement, like if you don't speak English or if you're deaf and you need an interpreter, you need to let the court know that there's an issue. We also have what's called the RPEA. That's what we talked about earlier, the Rules of Procedure for Eviction Actions. It says specifically what has to be in that form. If you own your own properties, you can actually get those forms online at the Maricopa County Eviction website. They're free forms that you can do yourself. The second document is called a complaint. A complaint tells the judge in a breakdown, more of a legal breakdown, how much is the monthly rent? When was it due? How much are the late fees and how do they accrue? Is it per day? Is there a maximum? Is there a prior balance? What type of breach did the tenant do? All of those are discussed in the statute 33-1377, which is part of the Landlord-Tenant Act, and under the Residential Procedures for Eviction Actions. Attached to the complaint is the notice that you issued. So that notice tells the tenant, here's the specifics of what I'm including in the complaint. There's also something called a res notice. That's not something you would create. If you're doing your own evictions, you will get that from the Justice Court on their website. If you use an attorney, the attorney will add that in for you. It's like a little mini Miranda. It basically says, warning, tenant, the landlord is going to evict you. Here's what your rights are. Here's what your obligations are. Here's how you can fix it. And here's what happens if you don't come to court. And here is what a writ of restitution is. And by the way, the landlord may even garnish your wages. All that's a little mini Miranda right that's now attached to summons and complaints. So you file it. The law says the tenant has to have a hearing within 3 to 6 days. The courts have generally interpreted that to mean business days. So you're in court about a week. We come to the initial hearing. the judge is going to say, who are the proper parties? So it could be the owner of the property, or it could be a lawyer for that. It could also be maybe a partner if that person holds an interest in maybe the LLC, like an LLC membership. It also has to be the tenant who's in possession at the time we're in the hearing. So if the tenant moved out after, I'm sorry, I said that wrong, is at the time of the service. If the tenant gets served and they moved out, don't cancel your case. Go ahead and get your judgment. But if the tenant moves out and gives you the keys before they get served, you'd have to dismiss that case. And by the way, property managers, you're not allowed to go represent the landlord. So don't file this on their behalf. You're not licensed, and that can get you in trouble with the Department of Real Estate too. Then the judge is going to say to the tenant, okay, do you have any legal defenses? Are you having financial hard times? Is that why you haven't paid the rent? Is it something worse? Did the landlord fail to do something? In Arizona, we don't have rent strike. Many other states do. Rent strike is where the landlord says, here's a breach notice. The tenant goes, I'm not going to pay you rent. You didn't fix my air conditioning. I have roaches, and I'm not going to pay you. That's illegal. Arizona allows tenants to have some legal remedies, including the ability to actually fix things or have them fixed by a licensed bonded contractor. And they have some specific defenses involving habitability and other choices of choosing a remedy. That is something they had to do before we came to court. So the judge is going to ask, have you done that? Did you give the landlord a written notice? Did the landlord fix it? Did you hire somebody? Where's your proof? At that initial hearing, that's usually all that happens. The judge will set it over for an actual trial. In the actual trial, here's what happens. The court brings the parties in. He swears them in. He or she swears them in. Both parties give an opening statement. Basically, judge, here's what we're here for. Here's what we're going to talk about. Here's what I think the evidence is going to show. Then the landlord, the plaintiff, puts on their case. The tenant's allowed to cross-examine the witnesses. So make sure you bring witnesses to court. If you're going to say noise, you can't have a letter from the neighbor saying, hey, it was noisy. You need that neighbor actually in court to testify. And then it goes back to the landlord or the landlord's attorney, and they explain whatever they just explained on a cross-examination. It's called a redirect. Then the tenant puts on their case and explains all of what they want and all their witnesses. There are very few counterclaims that are allowed in an eviction case. The tenant may have rights, like maybe they fell down and broke their foot. That's why they couldn't pay the rent. That's not part of a landlord-tenant eviction case. They'd have to sue in a separate case. It's called a tort. It's not a defense to the non-payment of rent. And then the court hears all of that and does closing arguments. Tell me what you want to tell me. Tell me what you told me. Tell me what the law is. Be careful what you do at court and what you bring to court, because sometimes you lose because of how you're perceived by a judge. Judge thinks you sounded really, really mean. Tenant says, well, judge, I understand I didn't pay the rent, but I had to move out because there was a fire. And I didn't have the ability to live there. Or there was no air conditioning, and I've got a newborn baby, and I told the landlord, and the landlord said, I don't care, just sweat it. That sounds really terrible. You want to make sure you look good in front of a judge, because the person who wins can actually get attorney's fees. So that's why lots of times you see that we have some kind of settlement, and that's why we try to get a resolution. Also, if you settle, you don't have the tenant doesn't have the right to appeal that ruling. So getting a settlement is always a better idea. If you're worried that this case is not very strong, you might want to think about getting a settlement, or even if it's a very strong case, settlement just ends it there. Remember that if you lose, if you brought a case and you did not win, the landlord's going to be entitled, the tenant's going to be entitled to attorney's fees if they brought one. We talked about this at the very beginning of the case. Does your lease have a jury trial waiver? I can tell you most leases don't carry them. It's not something that's automatic. If you're using an AAR lease, it is not in there. There's some other suggested phrases and clauses that you might want to think about, like carrying guns in a common area, allowing fireworks, that kind of stuff. You can find those on our website. You don't have to use us as a lawyer, but all of that is free on our website at drevictor.com under suggested phrases and clauses. So this is really important. If you don't have it, you really want to add it. So the case is over. The tenant's told they have either 24 hours to move out, if it's an immediate, so shooting, stabbings, could even be lying on your application, that's an immediate. Everything else is 5 calendar days. So the judge says, here's the judgment, this cancels your lease or your right to be there. You have either 5 days to move out or 12 to 24 hours. When they don't move out, nothing happens automatically. You're going to have to call the constable or file what's called a writ of restitution and have the constable come out and change the locks. while you're there. The court can't move the writ of restitution date. And by the way, it's the landlord's job to provide the locks. You can do a locksmith, or you can actually go and bring a new set of locks yourself. And make sure you have those at the time the constable or the sheriff's coming to do the lockout. So if a tenant doesn't move out and they still have stuff there, it's a little complicated. First of all, they're going to be arrested and charged with third-degree criminal trespass, just as if they leave and sneak back in the middle of the night. Don't call the lawyer, call a cop and let them know this is trespassing. I want to press charges. If there's stuff still left on the property, this is critical, and most of you forget to do this because you don't do evictions very often. You must issue a 21-day notice. This says, I am going to hold your stuff for 21 days, either on site or somewhere else. And you can only come and get certain items. You can come in once right now and come and retrieve everything, but I'm going to turn off the utilities, so get your pets out, get everything out of the property. That particular notice needs to tell the tenant how long you're going to hold it, that they have the right to come and get some certain things, important documents and medication without paying you anything, only one time, by the way, and then otherwise they can't come and get that stuff until they pay you the cost to move and store. By the way, that is not the judgment. But what about the pets that are left behind? What do they leave animals? I can tell you, you are required to store those animals for 21 days. What does that mean exactly? That's the confusion. We're working on some statutory changes right now, but you're going to have that animal boarded somewhere and taken care of for 21 days. There's some other issues about disposing of the stuff. Be careful if you don't have a good idea about how to use a 21-day notice. Once again, on our website, we have a whole section that talks about what do I do with their stuff. You have to hold abandoned stuff when the tenant skips out for 10 days. But and you have to send a special 10-day notice that says I'm getting rid of that stuff. It's 21 days if it's after an eviction. Be careful. This notice, this 21-day letter or the 10-day location of abandoned property letter says it must be sent certified mail, return reset requested to every address you know. So if you have an emergency address or work address, you have to send it there. And then it says that you're allowed to then go in and sell it. By the way, this particular statute we're talking at the bottom, 33-1370, says if the lease includes this language, you can throw away the stuff if it's been abandoned. Not if they've been evicted, but only if it's been abandoned. By the way, the AAR lease does not include this clause. So if you want to be able to dispose the stuff because it doesn't have much value, it's mostly garbage, you have to have some specific language in your lease. What do you do about a security deposit? That is a whole nother issue. You're required to do that within 14 business days after the tenant moves out, after they've removed their possessions, and after they've sent a demand. By the way, don't wait until they send a demand or you might be behind the ball. So we're getting close to time here, so let's see. Do we have any questions?
We do. So what if you own an RV park and the tenant owns their own RV?
Great question. So the question is, what if I own an RV park and the tenant owns the RV? There's actually a special law, a whole entire special statute called the Long-Term Recreational Vehicle Act. It's not something we're talking about today. It's very complicated, but it generally has a totally different set of laws. They too have a 5-day notice to vacate, but it's not the same kind because you don't own the trailer, the thing on top, and the land. Residential, you have to own the land and the thing on top of the land. If it's not a long-term RV park, by the way, it's also a different statute that's considered the commercial statute. If you have any questions, feel free to email those to me directly and I'll answer that because that's a little more complicated.
So if you call, read this correctly. If you call it due in 5 days because you plan to hand deliver, but they are not there and you mail it, do you have to rewrite the notice or can you just wait 5 more days?
Great question. That's a very good question. If you're using the standardized notices put out by AAR or put out by any attorney or even put out by the court website, it says on there it's 5 days from when they receive it. So you wouldn't change the notice. You would just mark on your form how it was given and you'd have to wait the additional time. Very good question, by the way.
Tenant is on a month-to-month. Does the 30-day rule apply?
Yes, if the tenant's on a month-to-month, that is when you would non-renew. It could be at the end of a term lease or at any time during a month-to-month lease. So if the tenant has a month-to-month lease right now, which means either there's no lease at all, no written lease, so it's an oral month-to-month, or let's say they had a lease last year and it expired last February, and you just haven't renewed it. That's now a month-to-month lease under the same terms and conditions as the written lease. So at any point, either one of you, the tenant or you, could give a notice that at the end of the following month, so you can give it any time you want during the month. You can give it today, you can give it in 2 weeks, but anytime in September, they have to move at the end of October. Question?
Let's see. What are the steps to do if the tenant breaks the lease and has an outstanding balance?
Okay, so if the tenant's going to break the lease, I'm going to presume we call that a skip. So the tenant says, I'm not going to fix it and I'm going to get out. If they're skipping out, you would, as soon as you get possession back, either from a constable, because you did an abandonment process, because the tenant calls you and says the keys are on the counter, however you get the keys back, now you would have to do the security deposit disposition. You have 14 business days. In that disposition, you're going to accelerate the rent through the end of the lease term. So right now, they may owe you 5 or 6 more months of the rent, of the utilities, of the yard maintenance, of the pool maintenance. Whatever their obligations are, they still owe you. So in your initial disposition, you don't know how long it's going to take to get it re-rented. You would accelerate all of those issues in the initial security deposit disposition. Now, be careful. Once you get it re-rented and you know the actual numbers, now you have to amend that or supplement that and call it an amended or supplemented disposition. If you evict the tenant because they didn't pay the rent or because they had an unauthorized dog, whatever reason, they still owe you exactly the same things I just said. Just because you evicted them doesn't mean they're now get out of the rest of the lease. You would just accelerate all of those issues on the disposition. You would still charge them the lease break fee or whatever your lease allows.
What's the average cost of an eviction?
The average cost of an eviction is about $200, maybe $250. It can be up depending on how many evictions you do. It can be a little bit less, but typically it's about $250. I can tell you most of the realtors have special arrangements with attorneys, like our office. And if an owner goes through the real estate company who has a relationship, we call it credit, established, a line of credit already established with that attorney, it can go down to about $200 or less.
Do you have to get a second judgment if you add money to the total?
Great question. The eviction judgment is just that. It's only an eviction judgment. It's to give you back possession of the property. And that's why if the tenant's moved out, you can't do an eviction. You already have possession. The secondary judgment may be for all the other things they owe you, for the rest of the rent, for the physical damages to the property, for maybe the duplicate commission the owner had to pay because the tenant didn't fulfill the first lease. All that additional amount of money, if the tenant won't pay it voluntarily, excluding what you already got on your first judgment, would in fact have to be a second judgment. If it's under $3,500, and remember, exclude the amount of money you're holding for deposit and exclude the original judgment. If the balance is under $3,500, the owner can file it themselves as a small claims. You cannot represent the owner in a small claims. You can be their witness, but you can't represent them. Otherwise, it would be a civil case under $10,000 or Superior Court for over $10,000.
So say your tenant is in a 12-month lease that has not yet matured. The house is falling apart, plumbing issues, roof leaking, etc., and they want out. What happens to the security deposit?
Okay, great question. Part of that depends on how bad the house is. If the house is in very bad shape and the tenant gives you a 10-day noncompliance, because by the way, the tenants can give you a 10-day notice or a 5-day health and safety. If the tenant gives you a notice or gives the owner a notice and things aren't fixed, then the tenant can break the lease legally after that 5 or 10-day period, or they can hire someone, a licensed bonded person, to come in and fix those things. There's some statutory language that limits how much they can do. But for certain things, they're allowed to go in and fix it. Or they can just break the lease and they can sue the owner for their moving costs, for duplicate monies they had to pay in rent, for hooking back up the utilities. So don't just let a landlord go, okay, I'm not going to fix it. I want to sell it anyway. The tenant can move because the owner's going to have some repercussions. So if it's worse than that, let's say there's a flood. Let's say you're in Houston, okay? There's a terrible flood. The lease is called mutually canceled because it's called a casualty event. Fire, flood, something very bad, and they can't live there anymore. Could be mold, by the way. Then the lease is mutually canceled. The tenant gets back their prorated rent and their security deposit as soon as they return possession. Sometimes there's nothing to return except for physical keys because the house has been completely ruined. Sometimes they can't go in and get things because the fire department hasn't released it. Those are complicated, so talk with your attorney, but the tenant could get out of the lease. And sometimes the tenant doesn't want to live there anymore. The landlord doesn't really want to fix it, but nobody wants to sue anybody. They just want to do what's called a mutual rescission. You can do that. Be careful. Use an attorney. And you can do a mutual rescission that says, look, I went out. Maybe the tenant wants to go buy a house. Landlord wants to sell. Something's wrong with the property or nothing's wrong with the property. You can mutually cancel it and sign a document that says everybody's going to walk away and they're all going to get their prorated rent or their deposits back.
So the same rules apply for commercial property?
No, commercial properties are a completely different set of laws. In fact, the notices are different. The time periods to cure are very, very different. Under Arizona law for commercial, it really depends on what your lease says. Some leases say 3 days, some say 5 days, some require a written notice, some do not. The commercial statutes are only about 3 pages long. The residential are about 40 pages long. So it's very, very, very different.
So any additional questions? Let's see, they want to see your contact information again. Sorry for this. There's probably a quicker way to do this.
So while we're looking at that, we've got a couple more minutes. Just wanted to give you some information about some new things that are happening in the law. We just passed an Arizona law that said the state can't require us to use a certain form. So yay, AAR, you did a great job having that battle for us, along with some other agencies. There are some new fair housing laws that are involving service animal, assistive animal. We've got a great article on AAR's website. I also have one at my website. You need to be very aware because there's a lot more fair housing cases than we've ever seen. Also, the rules changed more than a year ago about dealing with felons and whether or not you're going to rent to someone with a felony history. You can't any longer completely ban them forever. You need to have a reasonable policy. Both AAR and my website, we've got some good information about how to create that policy, how to decide what felonies you're going to allow and not allow, and the time frame. So lots of other information happens very, very quickly. If you want to stay up to date, make sure you're looking at the AAR website or go and use someone like my website too.
And how would they get started with the process?
The question is, how do you get started with the eviction process? The first one is you just need to know, have you followed all of the things you need to do before you can hire an attorney, or if you own your own property, go and file it yourself. So first of all, make sure you use a good lease, make sure you use good notices, make sure your notices are clear, that they very precisely say what the tenant did do or did not do. You wait the cure time or the time for them to fix it, that you've delivered it the correct way, and then you're ready to file. Once you're ready to file, if you own the property, you would go down to the court or go to the court's website, and that is maricopa.gov. If you're outside the city, you can still use those forms. Even if you're outside the county, you would just change the name and put your court. Or check if you're in a smaller county like Pinal or Pima, they actually have those on a website too. So you can download the free forms or go to the court and pick them up. You file the eviction. They give you the court date right then and the court time. Then you need to hire a process server or have the court constable or a sheriff serve that for you. And that's really how you get started. And then when you come back to court, make sure you have all your paperwork. Make sure you've helped the court by filling out a proposed form of judgment. So you're very clear, what am I asking for? What am I entitled to? What happens the first week of September? A lot of landlords forget to ask for September's rent when they're in court because they filed it in August and they just forgot. So make sure you understand that if you don't know what you're doing, really good idea to hire an attorney. It's not very expensive, like I said, a few $100s, and then you know for sure you're doing it right. Because if you do it wrong and you make a mistake, you're now responsible for what's called wrongful ouster. That is very dangerous. It means the tenant can sue you for quite a bit of money because you didn't follow the rules right.
So after a writ is executed, can you charge the tenant in advance of them coming in to get their stuff, and how much?
Great question. So after the eviction is completed, and the last step is called the lockout, that's by the constable, so don't do it yourself. Make sure you have a government law enforcement person with you, and they take a big sticker and they put it on the door and they say you can't come back unless the landlord gives you permission. You should immediately draft the 21-day form, once again that's on our website, that says here's how you get back in. We suggest that you let the tenant come in once and get out all the important things. Their immigration papers, their checkbook, medication. It's better to let them come and get everything they can, but after that initial time, you do not have to allow them back in until they pay you the cost to move and store the items. If you're going to store them on site, it's the daily rental amount. So if the rent's $900 a month, divided by 30, and by the way, it's always 30 regardless of how many days of the month there are. So 900 divided by 30 is $30 a day. They owe you $30 a day from the date after the lockout, the following day, up until they come and pick it up. And if they don't pay you that, you don't have to release the items. There's one little caveat. If they tell you they're going to come and get it, you would add 5 extra days to the 21 days. So potentially up to 26 days.
So if you provide a service, something like landscaping, and the landscaping company that you're currently using goes out of business, and it takes a while to find a new person, a new service, do you owe the tenant anything for the...
Good question. If you are not making those repairs right now, maybe because the owner doesn't have the money because the tenant didn't pay the rent, or maybe because there's so much work to do, it's going to take a while, you need to still do the disposition right away and put down estimates. At least get a pretty good idea of what it's going to be, because if you wrongfully refuse to turn over that money back to the tenant or wrongfully fail to just itemize it, you're going to owe the tenant the full amount of the security deposit plus 2 extra times the amount, so really triple the amount of the original security deposit. So do everything within your power to at least get the estimates out, and if you're going to estimate low, because if you estimate high and now you're wrong, that $200 bill that you held back, now you owe the tenant $600 because it triples the amount. So be conservative. The other thing you need to do is make sure you know what you're doing when you're deciding how much a tenant owes. If the carpet's terrible and you have to replace it because it's been so let's say animal urine, take a sample of the carpet, save it, wrap it in a Ziploc bag and save it. Take a part of the pad underneath it, part of the drywall. Put those in bags, seal them, because pictures don't really explain to a judge how bad things are. And if pictures are worth 1,000 words or $1,000, smell is priceless. So have all that evidence ready. And remember, you have to prorate the life of the carpet. They don't get brand new carpet if the carpet's already 10 years old. So when in doubt, we always say, when in doubt, check it out, talk to a lawyer, make sure that you're asking for the right thing, because the owner is going to be held liable if you're the one who made the mistake and you're a property manager.
So if you have a judgment and they give you the keys before you actually get the writ, but they leave some stuff behind, can you just toss it, or do you
I'm glad you brought that up. So if they give you the keys, there's a difference of opinion. It might be considered abandoned property, but the abandonment statute 33-1370 really envisioned where someone just disappeared, not where they gave you the keys. So the safest bet is if they've left stuff behind and you actually have the keys from them. You certainly don't have to do the 21-day form, but you might have to do the 10-day location of abandoned property. Best of all, reach out to the tenant. Say, hey, you left these things behind. I'm going to charge you for storage. So do you want to come and get it, or can I throw it away? But make sure you have that answer in writing.
Okay, I think that's all the questions we have today. Thank you so much, Denise.
Thank you. We're out of time. Have a great day, everybody.
Thanks. And our next webinar will be a broker brief on September 13th, and we hope to see you there. So have a good day.